If you've ever hired builders, renovated business premises, or tackled a loft conversion, you've encountered construction law. It's the essential framework underpinning every construction project, from first idea to final handover. Whether you're a client, contractor, specialist, design professional, or investor, if you deal with construction projects, this episode is for you. Construction law dictates how contracts are forged, the deals that bind everyone involved, how risks are identified and allocated, who carries the can for what, how payments flow, ensuring correct and on-time payments, how disputes are resolved when plans go awry. It's a heady mix of contract law, other legal duties such as duties of care, and specific legislation and regulations. Let's break down its core components. Contracts. These are the absolute bedrock. They define the scope of work, payment terms, those all-important deadlines, and everyone's precise responsibilities. Get your contract wrong, and even a minor project can escalate into a significant legal headache. Legislation and regulations. Think of these as the official rulebook. Here in England and Wales, key laws you must know include the Housing Grants, Construction and Regeneration Act 1996, crucial for payment mechanisms and the right to rapid dispute resolution through adjudication. The Building Safety Act 2022, driving higher standards for fire and structural safety, particularly for taller residential buildings. The Building Regulations 2010, setting the minimum technical standards for how we build safely and correctly. The Construction Design and Management Regulations 2015, vital for managing health and safety on site, from project inception to completion and beyond. That's not a complete list. Fail to comply with the law, and you risk serious liability, hefty fines, and, in some cases, even criminal sanctions. The time cost quality triangle. Every construction project juggles three interdependent factors. Time. How long does it take to complete? Deadlines are paramount. Cost. This is the budget. Labour, materials, equipment. It all adds up. Quality. This is the standard of the finished build. Does it meet the specification and the performance requirements? Crucially, alter any one of these three factors and you'll almost certainly affect the others. Disputes are what can happen when a project derails. Is it running late? Massively over budget? Or is the completed work simply not up to scratch? Construction law and those vital contracts help determine who's responsible for the consequences and how liabilities are covered. That brings us to dispute resolution. Construction projects are complex, often involving vast sums of money, so disagreements are common. In England and Wales, besides formal litigation, key alternatives include adjudication for swift interim decisions, arbitration. This is a private binding resolution process. Mediation. This is a form of facilitated negotiation which can help reach a settlement. Expert determination. This is a decision by an independent expert on particular issues. Many of these are designed to resolve issues efficiently, keeping the focus on project delivery before things escalate. Ever heard terms like liquidated damages, variations, collateral warranties, or novation, and wondered what they mean? We'll explain these in future episodes. We'll also unpack standard formal contracts, like the JCT and NEC suites, and explore the legal landscape when projects encounter turbulence. Construction law intersects with planning rules, procurement regulations, critical health and safety standards, intellectual property, and insurance. This makes it one of the most dynamic and fascinating legal fields around. Whether you're developing a skyscraper or managing a modest fit-out, robust construction law knowledge is your central toolkit. Projects involve huge sums, a complex web of businesses and people, and are, unfortunately, prone to delays, spiraling costs, defects, and safety concerns. There's a lot at stake. Being proactive is essential. Knowing construction law can help you prevent problems before they start, rather than just react to them.